Similarly, following this precedent, 215A3 could add, and this is a text similar to what the Cobble Hill Association suggested, in early and mid-19th century residential row house blocks, the introduction of new openings into row-end walls originally designed to be without windows may require a certificate of appropriateness. The solid-to-void ratio of such walls is a significant original feature of early row house development, the blank walls being designed to create a sense of enclosure in the gardens they abut and limit the exposure of historically private spaces. I don't know, Mr. Chairman, how long I have here, so that I have a lot of comments.
We certainly will leave them and we will consider them carefully.
Okay, well, I have lots of copies. Shall
yes, that would be terrific.
Okay, fine.
And if there's anything you'd like to especially point out or note, please do.
Delighted with the restrictions on out-of-scale additions in the rear yards of rooftops. Oh yes, the elimination of the minimally visible requirement on rear yard extensions. We would like to add something to that the extension does not call undue attention to itself by virtue of its color, material, reflectivity, or configuration, and does not obstruct visibility from the public thoroughfare of central green space within the block. So I have a lot of copies. I would love it if they could be distributed.
We will distribute them and we will also carefully consider them in our review process. Thank you for your testimony. And Liz, Lenore Norman. As always, welcome back.
Thank you so much. You're so gracious. Commissioners, Mr. Chair, Commissioners, I'm Lenore Norman. I am co-chair of the Preservation Committee of Community Board 7. I'm not going to read my whole thing. I'm going to give it to you to go through it so that I know in the interest of time it will be too long. Thank you very much for giving us the opportunity to comment on these rules. The most significant issues presented by the proposed amendments are the purpose and anticipated effect of these amendments will be to eliminate in an increasing number of cases a robust public process of examination of proposed changes to designated buildings and districts, denying neighbors and the community at large notice of or any voice in such changes. The proposed amendments relating to rear yard renovations and rooftop additions seek to apply broad general rules without sufficiently acknowledging that interior courtyards courtyards and rear elevations are integral elements of the character of the designated buildings and districts, and that any decision regarding proposals to alter or amend structures that adjoin such elements should weigh the nuances of the impact of such changes on a case-by-case basis. These amendments are broadly worded using at times vague terms that will confer extraordinary discretion on matters of subjective judgment on a staff that is already pressed for time, without a meaningful public process for review or appeal. Creating an opportunity for renewals of temporary installations that they can last 3 years makes those installations anything but temporary. Increasing fees will create an incentive for owners to evade the review and approval process unless the funds generated by the increase can be dedicated to increasing the number of staff and the resources available for the increased workload. I'm going to jump forward now, leave you the details.
Great.
Lest the Commission believes CB7 has only criticism to offer, the proposed amendments include 2 positive revisions that merit particular mention. The requirement that any plan for a temporary installation include an acceptable plan for dismantling, storing, and reinstalling any significant features that had to be removed to perform such work. It's a welcome and forward-thinking clarification, as long as they don't meet the fate of the Bogardus Sparks, if any of you remember that.
Okay.
The cross-reference between rooftop additions and rear yard incursions, limiting staff approvals to situation where only one is permitted for Section 5 of the proposed amendment, is an equally welcome means to define the scope and burden of the approval being sought without a full public review. In conclusion, we respectfully recommend that the proposed amendments be redrafted to reinstate the opportunity for the community to be heard on the types of changes outlined below to ensure that the impact of proposed changes on all aspects of the character of the designated structures, including rear yards, are balanced and taken into consideration, and to provide greater clarity for an increased incentive to meet obligations relating to projects affecting designated structures. We stand ready to assist the Commission in any way possible to achieve these goals. Thank you.
Thank you very much. Landmark West.
Good morning, Commissioners. Christiana Pena, Landmark West, and I'd like to read the following statement regarding the proposed rules amendments on behalf of our organization. And in actuality, our statement is much longer than what I'm able to present in our 3-minute allotted time. So I've handed in our full statement along with some supplementary materials that are circulating for you now.
Okay.
The Commission's website provides the following history on breadth. The Landmarks Law was enacted in response to New Yorkers' growing concern that important physical elements of the city's history were being lost, despite the fact that they could be reused. The Landmarks Law, and thus the Landmarks Preservation Commission and its rules, were born from the public's commitment to protect the city's significant historic resources. The landmark review process serves the public. It should not only acknowledge the perspective and interests of owners alone. In their current iteration, however, the proposed amendments to the rules threaten to do just that, further obscuring the stewardship process from the public and moving deeper into closed-door review territory. Public review should never be considered a hindrance to the efficient process of landmark stewardship. Just the opposite. As architectural critic Paul Goldberger observed, the necessity of public participation in the review process and their unmatched knowledge of their own communities. Quote, members of the community understand the nitty-gritty of the neighborhood in a way that you can't expect a citywide agency like the Landmarks Preservation Commission to do. We're on the ground, and we understand the pulse of the neighborhood, and that's critical. You need that. The relationship between the Commission and the public is mutually supportive. The public relies on the expert staff and Commission to oversee the effective stewardship of our landmarks, and the Commission relies on the invaluable on-the-ground knowledge of the public. This connection has not been for nothing. As General Counsel remarked at a public forum to discuss the proposed rules amendments, what happens at the hearings is the Commissioners, over time, oftentimes reacting to the testimony that the public is giving over time, their actions sort of start evolving. So as we understand it then, the Commissioners' attitudes towards preservation have evolved over time, based in part on the persuasive arguments and necessary information provided by members of the public at public hearing. With this in mind, excluding the public further from the review process would be counterproductive. In considering the possibility of increased staff purview, we quickly realized that the existing staff review process is largely a mystery to us, and we address this point more fully in our full statement. So, how can the Commission evolve without compromising the role of its most important ally, the public? Landmark West has begun to think through a possible system by which the public may be notified pre-approval of an application deemed qualified to receive staff-level approval. An initial draft of this system, along with our concerns regarding specific language of the proposed amendments, are attached to our full statement as well. Landmark West is grateful to have an opportunity to address the Commission on this matter, and we look forward to working with you to create more opportunities for meaningful and productive public input and involvement in every aspect of the landmark review process. Thank you.
Okay, thank you very much. Carol and Boulder and Deirdre Carson, both on their behalf, whatever order you'd like to testify.
Good morning, Commissioners. My name is Carol Van Gilder, representing the Real Estate Board of New York. We're a trade association of over 12,000 owners, brokers, and other real estate professionals, including developers. And we thank you for the opportunity to testify. Our Landmarks Committee took a lot of time to review these amendments, and we do have a number of comments. I'm going to address most of the sections, and then another speaker, Deirdre Carson, will discuss the committee's reaction to the revocation of approval amendments. Just to put this in context, as has been mentioned, right now the amount of work that the Commission and the staff is doing is incredible. The Mayor's Management Report for 2010 noted that more than 9,000 permits had been processed, and of these, only 296 were Commission C of A's. So already the staff is undertaking tremendous work, and the Commission is undertaking tremendous work that we appreciate. What's before us, however, is that the Commission continues to designate, including some very large districts, including hundreds of buildings. The concern is that if any more projects are pushed into the Commission C of A process, eventually your calendar is going to be so overburdened and clogged, it's going to be problematic for everyone, both the community, the Commission, and property owners who have been looking forward to staff permits in many cases to just get an expedited response. We're generally in favor of the rules because the rules clarify the Commission's standards and offer an applicant a path to a staff-level permit. However, these rules, we fear many are going in exactly the wrong direction. And instead of increasing the number of cases that can rely on a set of facts and move to staff permit, instead you're moving a lot of cases onto the Commission's calendar, and we think you're going the wrong way with that. Specifically regarding windows, on the limitation that windows on a secondary facade must match the predominant window sash on the primary facade or the front facade is too restrictive. I think that has to be looked at further. When you're looking at the rear yard additions, right now the proposed rule is a formula with 50% of the other buildings having a rear yard addition. We think that's not flexible enough, and that there may be cases where the subject site has an addition on either side, even though the rest of the block doesn't, and it may indeed be appropriate to have a similar addition there. So we'd like you to look at that. For temporary installations, it must specify that this does not include sidewalk sheds or construction fences, which are regulated by the Department of Buildings. And concerning rooftop additions, the height limit of 11 feet is too restrictive and should be extended to 13 or 14 feet, which would allow a more generous floor-to-ceiling height but still maintain the scale of a one-story addition. We also note that the height restriction does not have any provision to reflect that many roofs are pitched. It's unclear to us why the new restriction on having both a rooftop addition and a rear yard addition, why that suddenly become problematic. A lot of the rear yard additions are L extensions with no significant features and provide little usable space. They're often demolished in connection with a rooftop addition, and we just don't think it's clear that all of these need to go to the Commission, and this should be revisited. Just to summarize, we have a couple more concerns about the signs. The definition of sign should really match that in the zoning resolution or the building code. The use of the word advertise is covered by the zoning resolution, and it gets confused if it's redefined here. And the limitation on signage should really apply to a storefront controlled by a single retail establishment. There are multiple storefronts. It should be clear that one tenant is not penalized by extra signage on another storefront. And also we think the CNE cannot involve any excavation is too restrictive, since elevators and other mechanical systems may have a very limited excavation, and that should be accommodated. There's more written here, and rather than go through it, I will hand it in, and thank you for your attention.
Thank you very much. You're good. Carson?
Good morning, Commissioners. Deirdre Carson. I'm a member of the Landmarks Committee of Revenue. I'm going to speak today to the revocation provisions, about which we have a very substantial concern. Our concerns are prudential, they're textual, and they're procedural. So I'm going to paraphrase what I've written, because it's a little longer than I have time to say. But first, let me say that we're not opposed to the idea that there are circumstances in which the Commission should have that power. We are concerned about the authority to exercise it and how it's circumscribed. As a prudential matter, although it's not apparently necessary as a matter of law, it is the case that such agencies as the Buildings Department that have the power to revoke permits find that power in the New York City Administrative Code, and it is set out at great length, the standards and the circumstances and the procedures. It's also the fact that the Building Code is a huge volume or series of volumes of objective standards. We're going to come back to that later when we talk about standards for revocation. In this case, I think we can probably all remember the struggle some years back to try and add provisions to the Administrative Code that would give this agency certain enforcement authority with respect to the issuance of violations and the ability to issue stop work orders, which you already have in some circumstances. And the fact that this is being done, the revocation procedure is being done for the adoption of regulations, while potentially legal in terms of what administrative law would say could reasonably be implied in a statutory regimen. Nonetheless, when the legislature has so very carefully circumscribed and defined the circumstances and the nature of your enforcement capacity, as a prudential matter, I wonder whether it might not be best to do this through a legislative amendment that would establish the authority. Secondly, on a strictly textual basis, we feel that the way the standards for revocation have been enunciated needs some revisions and editing. The first is failure to comply with Chapter 3 of Title 25 or other applicable laws. A strictly literal reading of this would mean that you could revoke a permit granted by the Commission for a traffic violation or Sanitation Department summons for a dirty sidewalk. And no, that's not what's intended, but it is the way it reads, and so we feel that it should be redrafted to limit the ability to revoke to a failure to comply with the specific requirements of the permit or other approval that is sought to be revoked. The second standard, an incorrect or false statement or any misrepresentation as to a myriad material fact, is one of the grounds that is typically used in administrative law as a basis for an implied right of repeal. And it certainly makes a lot of sense and seems appropriate. But I do think that it needs just a little bit of tweaking and editing so that the language upon the basis of which such approval was issued should clearly modify the phrase incorrect or false statement. In other words, it must be the statement that was incorrect that procured the permit, therefore justifies the revocation. It is conceivable that some material fact could have been falsely or incorrectly, and sometimes innocently incorrectly, provided in an application, but it didn't affect the outcome. It wasn't the basis upon which the Commission acted, and therefore that should not be a basis for revocation. Now, it is easy to say, well, of course, that's not what the Commission will do. The Commission will, and its commissioners will at all times act in a reasonable way, but when we as lawyers look at these things, we always consider what is the possibility for abuse in circumstances where maybe the ideal this is the ideal commission, of course, but some less ideal commission in the future might not show the appropriate level of restraining judgment. The third standard, whenever an approval has been issued and error and conditions are such that approval should not have been issued, is, I think, not an appropriate standard for revocation and should be eliminated from the regulations. It is really encompassed in the second idea that there has been a misrepresentation of fact. I do see some possibility for some limited scope for error, but it should be very circumscribed. It's either going to be a procedural error, it's got to be some issuance of a permit in clear violation of an objective standard in your regulations. The work of this commission, particularly when you issue certificates of appropriateness or reports, is not based on the kind of code that the Buildings Department has in front of it. It's one thing to say you needed 3 means of egress, each of which had to be 36 inches wide, and you only had 2. It's another thing to say, well, we've changed our mind about whether that particular form of a building or that particular matter of construction or material doesn't really look the way we hoped it would look, and therefore we don't want you to proceed. And again, this group of reasonable and appropriate people would not do that, but we always have to draft in consideration of what might happen under other circumstances. Finally, I am concerned about the fact that the procedure here for revocation is very truncated. We deal with the buildings department frequently, so we've been through the process of revocation. The fact that there is no record created of any substantial nature on the revocation is a concern to me, because you go directly to an Article 78 proceeding from the commissioner's denial or decision to revoke, and there really is nothing but perhaps 2 levels of correspondence upon which that Article 78 review would occur. If you were doing revocation at the buildings department, you would have the option of going to the Board of Standards and Appeals for an interpretation which would generate a record. Or alternatively, very often violations are issued along with revocations at the Department of Buildings, and those have an ECB procedure, which can also be the basis for subsequent Article 78 review. So those are my 3 levels of concern. I have my written, the committee's written statements, and I will leave copies with you. Thank you.
Okay, thank you very much. Ms. Esther Williams, Historic Districts Council.
Williams, Historic Districts Council. In general, HDC finds the proposed changes to the rules for staff level permits to be positive ones that will help ensure the integrity of landmark buildings by setting forth clear standards of preservation practice that will allow applicants to receive permits more speedily when adhering to these standards. HDC is particularly pleased with the introduction of consideration of cumulative change, both in residential and commercial projects. This really helps treat the designated building as a whole instead of in segments. We find this a very welcome concept. HDC is also pleased to see that excavations are pointedly excluded from work eligible for expedited reviews. Even under ideal circumstances, excavation within an existing building is a tricky thing, and taking the additional time to bring such a proposal to a public hearing can only be regarded as good safety practice. With regard to the amendment to Section 2-15 concerning the insertion of windows on publicly visible side facades, HDC feels that they do not go far enough. Originally, the rule was established to ease the conversion and adaptive reuse of formerly obsolete commercial and manufacturing buildings. This, of course, is a very positive thing, but historically residential structures, particularly row houses, as we've heard, should be held to a different standard and should not fall under this rule. Additional windows on these types of buildings can drastically change the nature of a facade, or even the whole building, if the sidewall is transformed to resemble a primary facade. Often regularizing, as called for in the rules, with, quote, a regular and consistent pattern, end quote, and windows matching the front facade, if no historic windows are extant, is not the answer. Alterations to a facade visible from the public way should go to a full public hearing, so that the individual nature of the row is addressed. This would be consistent with the concept of cumulative change as proposed to be practiced in rear yards. Please note that our principal concern is with secondary facades that are visible from the public way. HDC finds the amended rules for new window openings in facades that are not visible to be acceptable. Rear yard additions to row houses are one of the most controversial issues in historic districts, and Section 2-16 addresses a number of residents' worries. While the rule does not allow for anything taller or deeper than what is on the majority of other buildings in the block, there remains the concern of how to ensure that the proper data is submitted to make that call. The modifier legal should also be included to ensure that the examples are being compared to grandfathered and commission-approved examples. The design and materials of the addition, not just its size and massing, should also be addressed. While commissioners regularly approve and encourage creativity, on rear facades at public hearings and meetings. Staff level approvals should be more conservative. Language should include references to keeping the historic style and materials of the existing structure, possibly a solid to void ratio, like what is proposed for new window openings could be devised, in order to prevent light boxes and the loss of privacy that neighbors worry about. Section 2-20 on signage has some very good, clear rules, like line 4, that specifies the projection allowable for sign panels and pin-mounted letters. But like the Friends of the Upper East Side Historic District, we are a bit concerned about some other vague language, like excessive or proportional, and we just ask that more detailed language be used in these lines so that they are less open to interpretation. Finally, the new section 7-06, or revocation of approvals, is an important step in enforcing the decisions made by the Commission. HDC asks that in addition to any incorrect or false statement or any misrepresentation in the document submitted, the wording include or material omission. Sometimes the lack of information can be more misleading than anything incorrect or false. While discussing these matters, it seems like a good time to reiterate the need for posting staff-level permits online, as is done with CFAs. It is important for neighbors and others to know what has been approved so that they can either be comfortable in the fact that the work going on is legal or be able to report to the LPC any violations which might occur. In this way, the public can still play an important role in the preservation of our city's landmarks. Thank you.
Howard Mendez.
Good morning, Commissioners and staff. I'm Howard Mendez, Chair of Landmarks Committee, Community Board 5, Midtown Manhattan. Although Community Board 5 has not taken an official position on proposed rules changes, some of our members have expressed concerns about these amending changes. These concerns fall into 3 areas. 1, the ambiguity of some of the language, or the vagueness, and a couple of the other speakers mentioned the proportionality in the signage, and also the visibility of rooftop additions, being visible from the public way and the degree of visibility. Greater clarity of language in many areas would assist the public as well as the commissioners reach difficult decisions on some of these changes. Some of our members find the proposed increase in staff approvals very problematic. There have always been staff approvals for which applicants are very grateful and which cut down the time and expense applicants must devote to their applications and getting things done. However, excessively streamlining the approval process will eliminate a great deal of public review by the community boards and the community at large. The staff has always reviewed applications and has given its opinions to the commissioners, but this proposal will eliminate the opportunity in many cases for members of the public to testify and to be heard by the commissioners and to have any input. This is extremely serious and should be further studied. 3, finally, since we understand that the Commission is in the process of going online with a computerized version of its rules, it would make sense to defer any rules changes until everyone has had more time to study the document and to consult with one another and to consult with outside professionals to consider the consequences of the new rules amendments. Now, I didn't realize you were also going to be considering the fees, and we have a comment on fees.
Please, that you can deliver it now.
Huh?
Sure.
Very, just
fine.
Quick.
Yes.
That there might be consideration of some waiver of fees in the case of hardship for small property owners in historic districts, such as in Brooklyn and Queens, where it really might give them thought to avoid coming to the Commission and doing the renovations on their own. So that would be something that you might consider. Community Board 5 appreciates your request for to study changes and to comment on them, and we really appreciate the fine work of the commissioners and the professionalism of the staff. It is our hope that we can always work together cooperatively and in the best interests of our great city. Thanks.
Thank you. Jack Taylor.
I'm Jack Taylor, speaking on behalf of Joyce Matz, who could not be here this morning and has asked me to read her statement. I am Joyce Matz. The better part of my life has been spent protecting and preserving historic properties, among them St. Bartholomew's Church, Town Hall, and the Beacon Theater. I'm on the board of several preservation organizations, and previously, and for many years, was chair of the Landmarks Committee of Manhattan Community Board 5. Now, speaking for myself, in the matter of the Landmarks Preservation Commission's proposed rules amendments, I have some very serious concerns. These concerns include the issue of fees, and equally important, the increase in staff approvals, which not only increases staff work, but unduly eliminates public input and review. The ambiguity of the language regarding rules in all areas is a problem which has always existed and is not now being corrected. Most importantly is the fact that these highly important changes in the LPC rules require a great deal of time and study by not only the preservation community, but also by legal and preservation professionals, time we have not had. Firstly, the issue of fees has always been a contentious one, since we have never known how much of that money goes to the LPC or to some other government body, and how much money we are talking about. In addition, the fees are inequitable, impacting more on the less affluent applicants, particularly in the outer boroughs, encouraging applicants not only to apply for permission for alterations, encouraging applicants not to apply for permission for alterations, but rather to do work illegally so as not to have to pay any fee at all. As for the increase in staff approvals, this is very problematic. There have always been staff approvals for which applicants are very grateful and which cuts down the time applicants must devote to their application. However, giving the staff more work is burdensome and, most importantly, cuts out a great deal of public review by the local community, a democratic process essential to our way of life. The staff always studies the applications and gives its opinion to the commissioners, but this proposal would eliminate the opportunity in many cases for the community to testify and be heard before the commissioners and to have any input whatever. This is extremely serious and should be studied further. The ambiguity of much LPC language has always made decisions particularly difficult, especially in cases of signage or the visibility of a rooftop addition. Is something visible from the public way? Partly visible? Exactly how visible should it or can it be? This issue needs more clarification of language in all areas to help the public as well as the commissioners make these tough decisions. The last point, a very important one, is the necessity for everyone to have more time to study the document, to consult with one another and outside professionals, and to consider the impact of all the rule amendments. I greatly appreciate the opportunity to study this document, and I applaud the fine work of the commissioners and staff, and trust we can always work together cooperatively and in the best interest of our great city. Thank you.
Okay, thank you. Elizabeth Finkelstein.
Good morning, Commissioners. Elizabeth Finkelstein from the Greenwich Village Society for Historic Preservation. We think that many aspects of the proposed rule changes would be positive. We are especially supportive of the additional changes additional conditions for staff approval of rear yard and rooftop additions, and for the change that would disallow the issuance of certificates of no effect for any rooftop addition on a house that already contains a rear addition and vice versa. However, we have some concerns and suggestions for improvement of some of the other proposed changes. The proposal to allow staff to issue a C&E for a minimally visible rear yard addition requires a judgment to be made without public input. As it stands, the public has no way of finding out when an applicant has applied for a C&E, and therefore no way to challenge staff judgment. Public comment is critically important to the approval process, and in many cases to date has greatly influenced the Commission's final vote. Though staff judgment may be based on the same criteria on which commissioners vote, at least through the certificate of appropriateness process, the public has the opportunity to affect the outcome. We are happy to hear that the Commission is working on the creation of a database through which the public could learn the status of both staff and commission level applications, and we think the proposed rule changes make this resource even more of a necessity. We are similarly concerned about the proposed amendments to Section 220, which would transfer a vast majority of signage applications from commission to staff level. Here again, the issue of language comes into play. For example, when saying that signage must not substantially reduce the transparency of the display window, what does substantially mean? Also, terms like excessive and proportional, what do they mean? These terms are not clearly defined, and therefore we are concerned about the ramifications of transferring these decisions from the public review process to staff level approvals. Furthermore, basing the dimensions and projections of proposed bracket signs on the historic use of the district, whether it be residential or manufacturing, could lead to some confusion. The Greenwich Village Historic District extension, for example, was historically a mixed-use neighborhood to which such a general rule may not always apply. In this case, what would be the defined proportions? Will there be a way for the public to find out how each district has been classified? Finally, we appreciate that the Commission is proposing rules to allow for the revocation of permits under certain circumstances. We encourage you to consider adding text to allow for permit revocation in the event of material omission. Thank you.
Okay, Jeffrey Kressler.
Good morning. My name is Jeffrey Kressler. I am a homeowner in the Sunnyside Gardens Historic District and a longtime board member of the Historic Districts Council. In many instances, the proposed rules do lend greater certainty to the process, such as clarifying the basis for approving rooftop additions or rear yard additions at staff level. But I am disturbed at the trend in the direction of having more decisions made at staff level rather than by the appointed commissioners. On the other hand, the new permit revocation rule is to be applauded. The proposed changes may distance the preservation community and the neighborhood advocates who have labored so long to support the Commission and to work with the Commission. Under the proposed changes, neighbors will have no knowledge of a proposed rear yard addition until the workmen arrive on Monday morning. The situation, even if it recognizes current practice, severs the bond between applicants, commission, and advocates. It also diminishes the recently expressed and intensely expressed concerns for the sparse greenhouse in row house districts, what's known as the donut, the open space. Even if we are discussing private rear yards, every incursion cuts down on the potential for groundwater retention and CO2 absorption. Further, the standard should not be whether it matches the existing, and who knows whether the existing additions are all entirely legal, but the original footprint, the original plan of that community. We are pleased that the rules for Sunnyside Gardens specifically, and the rules newly being adopted or proposed, do seem to protect Sunnyside Gardens with a degree of certainty. And this is certainly a relief to us because city planning has increased the FAR of Sunnyside Gardens for some unknown reason, so that most homeowners have 10-foot unused FAR that would be a rear yard addition. And so these rules, it seems, would prevent the likelihood of those being approved in error. I want to thank you for the opportunity for bringing these rules to the public. and I want you to know that most of them are really pretty good. Judy Stanton.
Thank you, Judy Stanton from Brooklyn Heights Association. Can I just comment on the fees since we have very little?
Coming back.
Okay, so, well, we reviewed the proposed amendments and agree that the rules changes will be beneficial in clarifying and strengthening each of the sections to which they relate. I'll come back and say a comment about fees.
Thank you. Lo Vanderwall.
My name is Lo Vanderwall, speaking on behalf of Carnegie Hill Neighbors. I want to echo the comments of many previous speakers. We applaud the care and the diligence with which these proposed rule revisions have been prepared. Applaud the detail. However, there are ambiguities, and I'll just focus on the rear yards, which are so important to us in Carnegie Hill. It's the basis for allowing the rear yard extension or a height increase is what is existing there. We echo also what has been said by several other people. Two aspects. One is the historical context of the large open spaces that are particular to certain blocks, not necessarily the entire Carnegie Hill district, but certain blocks. Even I would make the argument that the blocks between Park Avenue and Lexington have very open rear yards, historically speaking, whereas the blocks typically between 5th and Madison can easily exceed the zoning allowances, the 30-foot. Those rear yards are often smaller in certain cases. Also, so that if the criteria is what is there already, there's an additional danger that that for the extensions, I think the language is pretty good, although we still have the light box effect. That is, if somebody is suddenly hemmed in, whereas before they were not. But hopefully there can be some amendments in that to take that into account. Although it's difficult to conceive of an algorithm or a formula to do that. But specifically, I think we can make a correction in the height allowance, because the height allowance should not just be related to the average of the existing rear yard extensions. Because suppose there were 16 rear yards and only 2 had rear yard extensions whose average height was very high, then you're not allowing for a 0 value for the open rear yards that don't have extensions. So we hope some modification can be made, otherwise suddenly the rules allow you to create an engine that is doing something that you really don't want to have happen. Focus on the rear yards, because we have seen in the past staff level approvals that were detrimental to further developments into the rear yards. And I'm glad to say that I think that if these new rules are applied the way you seem to intend them, those egregious cases would not have occurred. So that's to be applauded. Finally, we also are worried about the public review process. If more of these applications are going to staff level, we applaud the fact that forthcoming will be improvements, as Mark Silverman mentioned at the February 14 meeting at HDC, that even staff level permits would be coming online at some future point. That would be very helpful, but somehow we feel that it would be helpful to know what is being considered at the staff level. And I don't know how this can be done, but we've heard at the community board considerations, and we've heard with collegial organizations, we all worry about that issue. Can we, it would help us even to know if something was happening if we could supply information, even though there needn't be a public hearing. So I think there are different kinds of formulas for making more public input work without hindering the efficiency of the process. I have a written statement, and I submit that, and thank you very much.
Okay, thank you, Lo. Further testimony from anyone? No one else signed up at this moment? Yes. Please.
Good morning, Chair, Attorney, and Commissioners. I'm Andrea Goldwyn, speaking on behalf of the York Landmarks Conservancy. The amendments proposed today will clarify certain aspects of the rules that regulate changes to designated properties, and as we have done in the past, the Landmarks Conservancy supports them. We feel that these updates reflect some changes in technology and codify precedents established by commissioners. Clear and comprehensive rules convenience both the applicant and the commission. They enable the public to understand what is expected of them in caring for a landmark from the outset. They also empower LPC staff to issue permits for routine work in a timely manner, thereby freeing up time to consider other more complex proposals. These updates should facilitate approvals for work on designated properties, ease the process for building owners, and allow for better compliance with the Landmarks Law. Thank you for the opportunity to present the Conservancy's views.
Okay, thank you very much. Anyone else? We're going to leave the record open for 1 week for further comment from everyone, and then as Mark said earlier, we will have, after those comments and all the other comments and our rethinking process, we will have a public meeting here for our further conversation. And do you want to add anything else, Mark?
So Commissioner, all of the written testimony will be, we're going to create it all, we'll send it off to you so you can do it. And then, as Chair said, I will be summarizing the testimony and providing you at a later date with the staff's recommendation on how to address that. And if you have any comments or any suggestions, please feel free to reach out to Sarah and myself as well.
Okay. Thank you. No, we're not closing that hearing. We're leaving the record open, closing the hearing. No motion to close and a second without objection. And we're going to do part 2 here. The proposed amendments to the rules to increase fees. This is our second hearing. This is continuation. Okay. Understand. Please.
Okay, so item number 2 is the proposed amendments to rules to increase certain fees for work approved as certificates of appropriateness and certificates of appropriateness and certificates of general effect. And this was initially heard on January 18th, and this is the second hearing.
Okay, I'm going to summarize briefly what the fees, why we're here, and then we'll take brief testimony and move to the rest of the agenda today. And and we've already, as I said, we've already had a public hearing on this, and basically as everybody knows, the commission only charges fees for work that goes to DOB. A lot of the work is particularly for that of smaller work, less impact, less costly work, requires no fee from this agency under this system. Permits for minor work, which include standard restoration, maintenance work, repointing, brownstone repair, etc. And there's no fee now, there will be no fee in the future. The fees that we do have, which relate to already in place, that do relate to work that is then subject to a building permit as well, collected seamlessly, we hope and we believe, at the buildings department. There will be, we are proposing a small increase for as follows. Right now, I'll just give the current fee structure: 1 to 3 family, new buildings, 10 cents a square foot, new building, all others 20, and then alterations on buildings, 50 for the first $25,000 of work, and $4, this is on all buildings, alterations, correct?
Correct.
And $4 for each $1,000 thereafter. The new fee proposal, 1 to 3, new buildings, 1 to 3 family, instead of 10 cents, 15 cents a square foot, new buildings, all others, 25 cents per square foot instead of 20, and finally on alterations, meaning permits, CAs, other work on that's covered by, requires you to go to DOB, not, instead of 50 for the first 25,000, $95, and then instead of $4 for every 1,000, $5. And then there are a few examples in here. 5,000 square foot single family home would increase from 500 to 7,500. The fee for a new 20,000. 750. What did I say there? 7,500. Well, it's a modest increase. Put us on sound financial footing for the next couple of decades. And then there are a couple of other examples, and I think it's self-explanatory. It's been promulgated and proposed for several months. I think the underlying premise of it also is to indirectly, but really directly, support the operations and work of this commission in times of budgetary and fiscal stringency, where everyone is pitching in and doing a little more, paying a little more, if you will, for vital, which I consider vital city services, and allows us to continue this agency at a sufficient strength to be able to carry out our mission. So for all those reasons, that's why we proposed it. That's what we hope ultimately will be approved. And this is part 2 of the hearing, second hearing. People who did not testify the first time around will have the opportunity to testify today if they wish. And I will first call on Christabel Goff.
Christabel Goff for the Society for the Architecture of the City. We passed on this the first time, but hearing that there is still opposition, we would like to say something. In the abstract, charging fees for landmark permits is not an ideal policy, given that owners of landmark sites already contribute to preservation objectives just by maintaining their properties. However, some revenue generation has become a political necessity for the agency. In 1991, we opposed a rather different fees proposal requiring a flat fee up front from all applicants. We thought that this was regressive as a flat tax, since the census showed families living below the poverty line in some historic districts. However, the rule as eventually enacted solved that problem. Now, fees are not universal, but are limited to work requiring a buildings department permit with a sliding scale that weighs on expensive major projects. Do fees discourage property owners from supporting designation? Those who oppose government regulation can be relied on also to oppose government fees. But owners who oppose regulation with fees may still oppose regulation without fees. An example is the Grace Episcopal Memorial Hall in Jamaica. Exempt from paying fees as a religious association, the congregation still blocked the designation. 20 years ago, according to a New York Times report, one preservationist testified, "I'm telling you now, if these fees are adopted, you'll never see another designation in Queens." But in the years since July 2004, when fees commenced, 5 historic districts, Douglaston Hills, Sunnyside, Ridgewood North, Ridgewood South, and Annesley Park have been designated in Queens, as well as a dozen individual landmarks. So contrary to predictions, including some of our own, we do not see evidence that fees have harmed the cause of preservation. The increases proposed here due to the sliding scale will fall mainly on large and already costly projects. Consequently, we have no objection to the adoption of this rule. And I'd like to add that if these fees didn't go to the general fund, A, it would be illegal, and B, if you stop and think about it, it would be pretty peculiar.
Thank you. Thank you very much. Jeffrey Kressler.
My name is Jeffrey Kressler. I am a homeowner in Sunnyside Gardens, and I believe I was the origin of the random quote that Christabel just held up for your ridicule. And I like to think that the error of my quote from 1991 has more to say about the advancement of the preservation ethos in the borough of Queens and among the citizens of Queens, rather than the fact that they have to pay money to have their work done. That said, I also want to say that this is a bad idea. When fees were first proposed in 1991, mine was one of the outer borough voices raised in opposition. And at the initial moment, very few Manhattan-based organizations thought this should be an issue at all. They came around at that point. The basis of our opposition was that the imposition of fees would punish the applicants who were attempting to go through the approval process legally, while winking at those dishonest owners who completed work without permits. At the time, there was no mechanism in place to fine malefactors. Eventually, the LPC did indeed gain the authority to level fines, though as often has been repeated, the goal is compliance, not revenue. Today we have fines, and we have fees, and the situation remains. The LPC is loath to impose fines except in the most egregious circumstances, while the honest applicant does indeed pay additional fees at the buildings department, and those fees are poised to increase. It is clear that to that applicant that the goal is revenue, pure and simple, and the applicant also knows that his proposed work is serving a public purpose, one that he more often than not supports. You can rationalize the increase by saying you have no complaints about it. Well, the fines are paid at buildings, so Landmarks is merely absorbed into the final total. Further, to whom exactly should we complain? And what should we expect from such outcry? Too many of us are just exhausted. By the way, my water bill just went up, and my property taxes just went up. Speaking as an outraged Queens homeowner, and not a experienced preservationist. The fees may indeed offset potential budget cuts to the agency, but this is an upward spiral which can only end when with the applicant seen as a revenue generator. This is not to say that the LPC will approve inappropriate work in order to generate fees, but the city will anticipate the revenue, will set revenue goals, and there will be increasing pressure on the agency to meet those benchmarks. What happens when the number falls short? I do not believe this is a prescription for good government. Thank you.
Okay, Christiana, thank you.
Christiana Pena, Landmark West, presenting the following statement on behalf of Landmark West Certificate of Appropriateness Committee. We'd like to echo the statement that we shared with the Commission at the first public hearing on January the 18th, when we stated that we fully support an increased budget of the Landmark Preservation Commission. However, there is no guarantee that increased fees will translate into more and much needed revenue for this commission. An increased budget could translate into additional staff and greater compensation for staff, thus increasing the ability to recruit and retain highly educated individuals as the frontline defenders of our city's architectural resources. Further, it could allow for upgrades of technology and tools for staff. Nowhere in the proposed amendments, however, is this monetary connection, increased fees equal increased commission budget, made. If applicants will be burdened by paying additional fees to maintain their landmark property, they should in turn receive improved services. Landmark West cannot support increasing the city's general fund at the expense of both landmark property owners and the Commission's own staff. Thank you.
Okay, Judy Stanton, DHA.
Thank you, Judy Stanton from the Brooklyn Heights Association. Our committee does wish to comment on the proposed amendment to section 1304, computation of fees, paragraph B, building alterations. Our committee supports the increase in fee from $50 to $95. However, we recommend that it be applied to the first $125,000 rather than the first $25,000. The committee further would suggest that the fees collected for the subject work be specifically allocated and payable to the landmarks. Commission. Thank you.
Okay, thank you. Anyone else to be heard?
Yeah. Linda Eskenas, the Preservation League of Staten Island in West Brighton, the Restoration Society. We believe that any increase in fees will result in the destruction of more buildings. Some of our oldest and most important buildings are not protected. And because people think that when they landmark, or they're afraid of landmarking, of course, because they say that it will cost them a lot of money. And of course, this is proving it. And I agree with what previous testimony regarding this. It will be it's the first question they ask people that don't know about it. We are dependent on these people because when we want a landmarking district, we're not just dealing with people that want to save New York and our buildings and our heritage. We're dealing with other people who must not object. And this will certainly, this is a terrible idea. Also, we know that this money will not go to the LPC. It will go, to the general fund. And what's worse, it will make, it will cause an increase in administrative costs. And because there are so many, when you deal with funds, the government requires you to have increased administrative fees because they're constantly, there are many checks and balances, and you need the staff to deal with all of this, as is required by laws of New York City. So it's not going to make money. Also, that it falls on small property owners, because we all know that in the 60s, when New York had so many, was going to be destroyed. They thought, as the tabloids said, New York dropped dead. We didn't drop dead. People, small owners, individual people that they need to love and save houses and have a stake in New York City and their heritage, went to all these terrible bad neighborhoods or faraway neighborhoods and restored New York. It was these small owners, and today these are not only the pride of New York, they're the identity restored. And all of us, we're all connected, and they express everything. I mean, Sandy Ground is, the triumph of the hero king spirit, but each neighborhood has its own different, wonderful meaning, and that's for everybody. Everyone can enjoy this. And of course, there are things that, anyway, a lot has already been said that I agree with, but we pay tremendous costs to DOD. I'm going through some building permit right now. It was incredible because it had to be renewed, and under new laws, we had to say, inexplicable to me, perhaps Mark can explain it, perhaps not. We had to say that it cost more than it did. I mean, in order to just, renew the permit. It's incredible. I wouldn't even have had that money. I mean, it's ridiculous. So we have the onerous taxes that I cannot tell you. And today is actually the deadline to appeal them, but the appeal process was made by a scam artist to assure that you can't win. It's incredible. I remember when you could challenge your assessment, and you just went there and you talked to a person, and they usually gave you a little. But now you just can't. Even if you live in your own house, they will charge you as if you are renting it for some phenomenal amount of money. So we have all of these problems, and this is just to raise revenue, although I must reiterate that the luxury housing and developers do not pay 1 cent of real estate taxes for 20 to 25 years. And this was a major source of income for New York City. the burden cannot be put on small property owners who want to save these wonderful houses and have always done it. And this, it's just a terrible idea, and it won't help us.
Okay. Thank you.
Thank you.
Thank you. Anyone else?